encourage them, to keep to time. Because if I had allowed my Lord, he would start, recalling most of those issues, that came up over the years as we were developing this law. Thank you so much, my Lord. Let's appreciate His Lordship again. Thank you so much, sir. Let me call my Lord Honorable Justice FCT High Court of the Federal High Court, representing my Lord Honorable Justice John Dehamba Soho. Let's put our hands together as my Lord takes the podium.
I want to recognize my Lord Honorable Justice Ogunwumi JC. It's a privilege to be here today, and I must say that my Lord Justice Ogunwumi was one of those people who groomed me. I appeared severally before my Lord as a High Court judge in Ondo State. I'm very, very grateful. My Lord JCA and Lenny Seke, the Administration of Criminal Justice Act has brought some developments. And like my Chief Judge, along with the CJ of Federal High Court, instructed me that the Federal High Court as a federal court, will continue to do everything lawfully possible to advance criminal justice and applying strictly the Administration of Criminal Justice Act. And despite some shortcomings, pending when they are addressed, the Administration of Criminal Justice Act shall be strictly applied by the Federal High Court, and he has helped the Administration of Criminal Justice in Nigeria. Thank you.
Thank you very much, my Lord. Let's appreciate the Federal High Court. Very, very central, a very, very central court to the effective implementation of the Administration of Criminal Justice Act. Thank you, my Lord, for such a powerful statement on behalf of His Lordship, the Chief Judge of the Federal High Court, and all your brother judges of the court. Thank you, sir. My Lord, maybe I should even call my Lord before my Lord Justice of the Supreme Court. Let me skip my Lord for now. Because when they speak, the matters are sorted. Professor Ali Ahmad. Right Honorable Professor Ali Ahmad.
My noble Lord, Justice Ogunwumi, whose service we cherish very well in Kwara. She was in Kwara before she came. My Lord, DCA, my learned judges and justices, especially Justice Shak, learned Silks, and my colleagues, good afternoon. I will not go on the jurisprudential. We've had enough. I will go on the lessons learned through my own experience. When I was a young lecturer, heard a lot about criminal justice reform. I was an attorney general in Kwara State, and I performed under the old rule. So when I became an politician, accidental, because I never looked like a politician, but I was dragged in. And I found myself as the chairman justice committee of the House of Representatives, the 7th Assembly. And I saw then Prof became very vivacious, very energetic, and told me about criminal. I said, oh, this, yeah, I knew the problems I faced as Attorney General. We've been doing conferences over conferences on criminal justice reform. He brought it. I said, give me the draft. He gave it to me. And I took about a month to read it. I was dumbfounded. I said, look, I will do this. But you know, the interesting thing, ACJ bill then was not a darling bill. This was a bill of 300-page bill. Honorable members are used to 3-page bill, 4-page bill, and then it comes with some perks. Yeah, those who are sponsored, you know what politicians are. This one, no sponsorship. So I met our brother, the Attorney General, That is one unsung hero in all this. Honorable Adoke, you will help me. You've just done a great job for the Evidence Act, which was sponsored by Seriake Dixon then. Fully supported by government. You say, Ali, I will not do this one. I know what I did for the Evidence Act. It was done, it was this. I know how much it, off record, how much it cost, how much is this. So this ACJL, very good, but carry your cross, go and do it. I came back to him. How do we do? Then MacArthur came in. Then how do you photocopy 360 copies of 360-page bill? They came in handy. Then meetings, sponsorship, all this. My colleagues, it wasn't easy. It wasn't easy. But one thing that I learned from this, Senator Dairo, and he was the chairman justice of the Senate. We did the bill together. I passed it very well in 10 months. Unprecedented. In 10 months, we passed it at the House of Reps. Then it was stuck at the Senate. The rule is that the Senate president does every other thing. The deputy Senate president does the law. Then it was stuck. The deputy Senate president is a lawyer, but for whatever reason, and I will run to, how do you, he said, Ali, since I said I will not fund this bill, the day you bring a clean copy of this bill, I promise you President Jonathan will sign it. I will call him month after month, say, are you still on this promise? He said, I say, I'd love that even more than the funding. So I will come, we will deliberate, we will go. Then another unsung hero, DD, Damien, SAN, because we normally meet with the Kano, we were all in Kano before we came to Abuja. Then he took the bill, met the Senate president, you will break the protocol, you will preside. He agreed the following week, from morning till 5 p.m. They were there, and it was passed. The following week, President Jonathan signed the bill. That's the history. Then Providence, then another experience that I will share. 4 months later, I was seated in a court. The provisions of the ACJA was being quoted. Issue was, what is the intendment of the legislature? I just laughed. I said, a representative of the legislature is here. But I couldn't speak. Say, oh, that's not what we meant. This is what we mean. This. I couldn't speak. And what was the issue? Whether where there is an appeal, the criminal proceedings would stall and all that. And unfortunately, the defendant was my boss, Senator Saraki at the CCT. And when the ruling of the Supreme Court came, the ruling, which I believe was the intendment, which were all the SN were arguing, that it applied to the CCT trial. And now the politicians in Kwara, I think we knew he should have known that when he was doing this ACJ, that perhaps Senator Saraki will be prosecuted. He shouldn't have, so that this case should last 10 years as the old brigade procedure. He should, so it what it out of political. So from House of Reps, I went back to Kwara Speaker, and as Kwara Speaker, I came back to him again. Of course, in Kwara, it was a roller coaster. It was passed, it was signed. Then we started again, and we saw to it that about 12 to 13 states through the advocacy, because we have our association speakers, were passed. So, ladies and gentlemen, things that will not be written and that are not written. Thank you very much, and that's the lesson I think I derived from this. Thank you.
So much, Professor Ali Ahmad, former Attorney General, former Speaker, former Chairman, Justice Committee of the House of Representatives, now a professor at University of Abuja. Your students are very lucky. Thank you so much, sir. Thank you. Let me also quickly invite Senator Dahiru Umar, who did the work at the level of the Senate. Please let's welcome distinguished Senator Umar Dahiru.
very much, my good friend, the professor. Let me adopt the existing protocol. I have just 2 minutes. My colleague here, who was with me in the National Assembly, has given some history of how this act was passed into law. I believe our greatest achievement then in the 7th Senate was the passage of this law. In addition to that, we have Saba Act. You may not believe it. When these 2 laws were passed by the National Assembly, I believe Mr. President, the then President Goodluck, was not even around in the country. But he was told the 2 laws were passed. He couldn't even believe it. He rushed in and simply signed the law. So you can see the achievement. Everybody was involved in the passage of this law, be it National Assembly, the executive, and everybody. The law in question that we are now discussing. Well, I learned now that some sections, as mentioned by the paper, that by virtue of the constitutional, as the constitution stands now, we cannot be able to enforce it. But we are now lucky. Constitutional amendments is now being done. Why can't we push some of the amendments, the professor? You are up and doing. We became friends. The first time I came across professor was when we were doing this act. And we came very, very close. Jezebel was there. I'm very glad he opened up the meaning of this act, maybe to the courts, to the judges in question. But I believe now we can still do something. We can encourage the amendment. We can unban the Constitution and make sure some sections that can support the administration of criminal acts can be imposed now. So with these few remarks now, I think maybe I've just 2 minutes and I've closed my case. Thank you very much.
Senator Dahiro Umaro, a man of few words but action. A man of action. The day we met him, I said, we have this. I said, no, my colleague has already told me. I'm working on it. You know, so thank you very much, sir. Nigeria celebrates you. Nigeria appreciates your contribution to development of
Nigeria. We have continued to play our role. We developed the plea bargaining guidelines for federal prosecutors 2023, signed up by the Honorable Attorney General of the Federation for clear procedures for application of plea agreements, and capacity building was organized for about 420 justice sector actors from November 2024 to July 2025, including the media. And this was supported by ROLAC and International IDEA, by ROLAC, same as International IDEA. Then we developed the practice direction on custodial and non-custodial measures 2020, working with the FCTI courts, with particular reference to Honorable Justice Ayu Bello, who ensured its success. And thereafter, we did carry out capacity building workshops for judges and other stakeholders. But I think that we need to do more of that. Then we set up 2 virtual courts at the Kuje Correctional Center to fast-track trial during COVID. We also have built and furnished 3 courtrooms at the Kirikiri prison, which will be handed over by the Honorable Attorney General of the Federation before the end of the year. Also recently, we have developed the record of arrest database, and the training of arresting agencies was recently done. The deployment is underway, and we are hoping that we'll be able to complete that. We'll be able to take off by December this year. And this was also supported by ROLAC International IDEA. The future of criminal justice reform must be built on effective implementation and not intention. That's the way forward. I just want to say a few things under the way forward. There is need to adopt the National Minimum Standard 2025, which was recently signed off by the Honorable Attorney General of the Federation. This document was developed in partnership with CSLS, and it provides a benchmark for states to align their administration of criminal justice laws to national minimum standards. It aims to deepen the implementation of ACJA 2025 and the AC date. It ensures that there is a baseline of quality to be met, uniformity and compliance. It ensures a common basis for evaluating criminal justice institutions. Also, it gives room for monitoring, for shaming of states who haven't performed, and encouragement and gifts for states who have performed. Then next, it's important that we promote non-custodial measures and sentencing. Like I said earlier, that we need to do. Did I say that? Because I remember stakeholders didn't realize that there was any document like that existing in FCT, and we were shocked, which means that we need to retrain and retrain. Then we need to leverage on technology for speed, transparency and efficiency, as this will help to decongest the dockets. Then we need to deepen capacity building for justice sector actors. Thank you very much.
Thank you. Please let's appreciate Mrs. Ayola Daniels. She has done a lot to bring sure that the full force of the Federal Ministry of Justice backs what we are doing at the Center for Social Legal Studies, as well as what all other civil society organizations are doing. Thank you so much, Ma, for your support, especially for the national minimum standards, which is the reason Attorney General adopted it and has now signed it, and now governing all this, available for adoption by all the states of the Federation. Thank you so much, Madam. My Lord, Honorable Justice of the Supreme Court will have to leave us shortly, but she has graciously granted direction that my Lord Honorable Justice J.O.K. Oyewole will speak, and then my Lord Honorable Justice Ogunmeji will take the podium, and then we'll continue deliberations from there. Please, let's welcome my Lord Honorable Justice J.O.K. Oyewole of the Court of Appeal, one of the founding fathers. Each time we run into difficulty, I will take my phone, I will call him, I will send him email. I still have your notes, my Lord. All those notes, and we are putting all of this together to create a documentary of the history of the ACJA. He will reply, you say, no, do it like this. This is how you should put the clause. He will even draft some of the clauses for us. Thank you so much, my Lord Honorable Justice J.O.K. Over to you, sir.
Please, since we are really pressed for time, permit me to adopt the existing protocol, but I must acknowledge my big sister, Honorable Justice Ellen Moronkeji Ogunwumiju, JSC. For me, sitting here, lot of nostalgia, and I think we should acknowledge, for historical purposes, the role played by Lagos State in the emergence of ACJA. The first administration of criminal justice law at all in the country was the one by Lagos State in 2007. And the learned prof could call me only because I chaired the drafting of the Lagos law back then, taking over from where my Lord Honorable Justice sorry, please let me try. We've been here for some time, please. Honorable Justice Olabode Roosevelt chaired the initial committee in Lagos State, and when my Lord was elevated to the Court of Appeal, I took over from him. Some of the sections now that we find very interesting and very relevant to the progress we are making in criminal prosecution today, a lot took their root from there. When today we talk about Section 306, we must acknowledge Section 40 of the EFCC Act, which was where we first toyed with the idea of enacting stay of proceedings. And it was the success of Section 40 of the EFCC Act that emboldened us to include it in the Lagos State law in 2007, from where it found its way to ACJA in 2015. And of course, because we have little time, Section 3967, if Prof will remember, it all started, I was a trainer for a judge's training in Ghana, and in the course of discussion, it turned out that our facilitator who was doing so in her capacity as a judge of the High Court, was actually a member of the Court of Appeal. And how do you combine this? And she said, no. In their jurisdiction, you are elevated to the appellate court. If you have unfinished business in the High Court, the Chief Justice of Ghana will give you dispensation to continue what you are doing in the High Court. I quickly called Professor Akisha Judge. I said, this is something we need. I called Mr. Falano. We must find a way. We can't be dealing with trials de novo simply because people are elevated. There must be career progression, but at the same time, that should not stall prosecution. Of course, maybe what we should have pushed for then should have been for it to be included as a clause in the Constitution. We have an opportunity to do so now. We've been guided by the wisdom of the Supreme Court in Odeogu, and we must continue. But one thing I just want to say is this. As somebody made it popular then, we have left Egypt, but we are not yet in Jerusalem. We had a time in this country where the accused person would trial. With the reform that had been made, that is no longer possible. We had a time in this country when, nobody would believe even little things like taking of statements. Now, when we had the debate, I remember then in Lagos, where technology, where will people, how can you be talking of people recording anything on video? Where many countries say, look, it could be futuristic, but let us set a standard for people to strive towards. And today, nobody will argue with you, because every decent film, whether made in China or Hong Kong, has facilities for recording and video. And this again, we are backed again by so many decisions of the Supreme Court that we can rely on. So please, what I will say is this. We cannot, especially for civil society, afford to relax. You must continually push the frontiers. We must continually push the frontiers. And once you do the legislative part, you can be rest assured judges don't make laws. We are there to interpret whatever has been made as laws for the country in a way that will benefit society. But it's also important that all these things are done so that nobody will be accused of going outside the privilege. We should be talking of something much more. Thank you very much.
Thank you very much, my Lord Honorable Justice J. O.K. Oyewole. Thank you so much, sir. And I must congratulate your Lordship on the admission of my brother to the inner silk. His Lordship's son was admitted to the inner bar this last exercise. Yes, thank you, my Lord. Congratulations, sir. We have to change the protocol a little bit, but I don't want us to rush. We're going to call His Lordship. Those of you who have not been reading Supreme Court or reading Supreme Court judgments, you need to start reading Supreme Court judgments. If you want to know law, go and read Justice Ogumiju's judgments, beginning from the Court of Appeal. Even when she's writing a dissenting opinion, you see law. She rarely says, I concur. No, she will explain why she's concurring. And that has defined His Lordship's contribution to development of Nigerian law. Very rich contributions. And when we were having issue, when we were debating these provisions, would they say through the Supreme Court? I said, don't worry, there are some justices there who will make sure that these laws, these provisions pass. So when we start setting decisions like Charles, Charles and FRN, there's this other one. Before Nadiofor, Zia and the people of Lagos State. There's still one more on a confessional statement where my Lord also participated. And then eventually we had Nadiofor, which has settled the issue of the mandatory nature of electronic recording, notwithstanding the fact that the AGIA uses the expression, the word may. With a standing ovation, welcome to the podium, my Lord, Honorable Justice Helen M. Ogunmejo. Let's put our hands together as my Lord intervenes.
Thank you very much. Please be seated. Thank you very much. It really gives me great pleasure to be here. I sat, then I rushed to NJI for a program Then I said, even if it's the last minute, what we Christians say, what is it called? The grace. I will come and catch it here so that I'll be part of this program. It's a very sentimental moment for me. And when we started the Administration of Criminal Justice Committee set up by Chief Akeolujimi when he was AGF, our head was Chino Obiagu. Very, very, very knowledgeable, very incisive, erudite lawyer. And I used to wonder how he used to be able to collate all our frenzied arguments and ideas. By this time, we would argue, we start meetings like 9:10 and end at 6 p.m. And by the following morning, Chino has collated and would be able to analyze everything he said and sort of bring everybody's ideas together. Wonderful, wonderful contribution in this regard. There are a few of us, Professor Akisha George, late C.C. Nweze, and there was a commissioner of police, I forgot his name now, and one other senior advocate. We thank God how far this endeavor has become, has progressed. And it's a testament to the tenaciousness of Professor Akisha George and Chino to get the bill passed into an act of the National Assembly. I know what it took them. And the country really needs to appreciate them for that singular effort. I just want to say one or two. The importance of training and engaging magistrates in this endeavor. I worked as a legal aid counsel officer and became assistant director legal aid. And I practiced in the north, practiced in Sokoto. Distinguished Senator Tahiru Umar may not remember, but he was part of those who organized my send forth when I was leaving Sokoto in 1987. My friends were late Abdulkadir Jega, now Emi Agumi, Salamatu Suleiman, and of course Buhari Bello, who used to do school run for me. The former chairman of the Human Rights Commission, he used to do school run for me. For those who are now SANs and all that, you know. So I as a magistrate, a chief magistrate for about 6 years. So I know the importance. The High Court judges and the Federal High Court judges, we only do a minuscule part of criminal justice dispensation in the country. Majority of the contact with members of the public and that part of society is by magistrates. In fact, in those days, I have a gist that when I was a magistrate, late Justice Ogundere of the Court of Appeal gave me a gist, which I always repeat when I'm talking to magistrates. In the early 60s, he said he was a lawyer in Lagos, and at his barber's shop, it was ministers and magistrates, 10 shillings, others, 5 shillings. So as the magistrates, everybody knew. And when I was a magistrate in Oyo, my High Court judge would complain, the prosecutors did not come, the lawyers did not come. Meanwhile, he mentioned their names, and they were in my court as a magistrate, because I could revoke the bail of their clients. He didn't have overnight, I had overnight, I could refuse bail. So the lawyers were in my court as a magistrate. Those times of magistrates in criminal justice dispensation. So these interventions should concentrate more on the magistracy. The issue of long detentions, non-custodial sentencing, that is where the education needs to be concentrated. We by the time you progress to become a high court judge and all that, most of these things are part of you. But when you start from that level of magisterial, at magisterial level, you don't know all these highfalutin, idealistic ideas of what an ideal criminal justice system should be. So it's very important that we make an effort going forward to bring in that the magistracy at all levels, because they have most of the criminal cases, and they are the ones that remain in custody at the flimsiest excuse. So they must be educated and they must be engaged in understanding the implication of their work and the ripple effect of the orders they make. And I want to mention something about professional statements. Yes, my judgment at the Supreme Court has been mentioned, where I interpreted, I said whether it's may or shall, it is the intent of the lawmaker that matters. And that the best practice would be that a recording of a confessional statement must be made, or his lawyer or the lawyer of the defendant or accused, at that point is accused, must be present at the police station. This scenario, as painted by Agja, what is most practicable is the issue of a video of the confessional statement. I have a lot to say about confessional statements. And as usual in Nigeria, is when you retire that you can tell the whole truth and nothing but the truth. So, I have a lot to say. Several years as a defense counsel, and I practiced for several years as a magistrate. So I know both sides of the eye. Get into confessional statements and how they get into confessional statements. So, but as I said, it is a matter for another day. So, but it is very important to educate police officers. I find that we neglect, when we are doing these interventions, we don't incorporate police officers, IPOs, into this. We just concentrate only on judicial officers. Where are the IPOs? Where are the police officers? When I was president of the National Association of Women Judges, I went to the IG then. I'm trying very hard. I've been trying to remember his name, so I can mention his name, because for me, he's a hero. I said, we need to have a special victims desk in every police station in Nigeria. And he agreed. That is what is now called the gender desk. In all the police stations, manned by a senior police officer, preferably a woman. That is why it's called the gender desk. So it is very important that we target people, and then we make an effort to ensure that the police have people that they train particularly as prosecutors. Because when I was a magistrate, we discovered that they can just post you, go and prosecute. And you know, sometimes as a magistrate in the rural areas, because I was posted to most of the rural areas in Oyo State, I would say this man had appeared before me. Maybe they say he stole 10 goats or something, and I sentenced him to 3 months imprisonment. He went. The following month, he had come out of prison, and he stole something again. And when I say, and when you are sentencing, you know, you ask as a magistrate, you are hereby convicted of stealing, blah, 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 blah. And then you have to ask the prosecution, anything known, as is the history of the convict, so as to guide you in your sentencing. The police officer will stand up, nothing known, my lord. I will say, I know. Go and bring my record book of 6 months ago. I recognize this man. I will now quote that particular incident, the case number. This man was convicted 6 months ago, so I'm not going to give him option of fine again. So there needs the police as an institution needs to get engaged the magistracy as an corporate institution. There's a National Association of Magistrates, and the NJI needs to be engaged in training magistrates in the criminal justice administration and dispensation of justice. These are areas where what we have now, it may not be perfect, but it is as best as we get now. Why don't we ensure that we utilize what we have now and engage people who are actually practitioners in this field to understand what it means? I would have expected that the Commissioner of Police, FCT, would, of course, it would not come, but the cadre of police officers who prosecute at the magistrate level will be here to be educated. I hope that is what you will do in another engagement. So we thank the Federal Ministry of Justice for all your laudable work in ensuring minimum standards of engagement with accused persons and defendants in court, because I ensured that the word defendant was used. You remember, instead of accused, it said accused when they are in, when the investigation is going on, but when a plea is taken, it should no longer be accused, should be defendant at a trial. So I thank God that I was part of the original group that started the criminal administration of criminal justice bill, and this is about 20 years or more, about 24 years now since we started. 2002, yes, 2002 to 2000. I was there 2002 to 2005. But when I became the justice of the Court of Appeal and was taking here and there, I could no longer participate actively in the endeavor. And of course, I thank the Center for Socio-Legal Studies for their work, and all other agencies and civil society who have contributed to making this work progress. Thank you very much.
Thank you, my Lord. Thank you, my Lord. Yes. We'll plead with my Lord. Please, kindly have your seat. We'll plead with my Lord to kindly allow us 10 minutes to round up the event. We are rounding up now. The panelists will take one speaking closing point, one closing statements from each of the panelists. Then Professor Essa, one statement, and then Professor Ape will conclude the meeting, and then we'll take a group photograph. We need to document this. All of this should happen in 10 minutes so that we don't delay my Lord for too long. Let's quickly invite the panelists. Essa, please. 1 minute, make a statement. Professor Essa Ononja.
Thank you, Prof. Prof, I'm Director of Academics, not Professor at the law school. Apologies. So, my Director General, Professor Issa Hayatu Chiroma, SAN, he sends his apologies. He's in Ghana attending the African Bar Association conference. On the ACJA, the Nigerian Law School was fortunate to be invited to submit a memoranda. It was that was when I met you, Prof, and my Lord, Honorable Justice Ishak Bello. I'd just like to mention that the Nigerian Law School owes a debt of gratitude to the working group for accepting its proposal with respect to the proviso to ACJA that talks about it obligates the police to inform the next of kin of suspects of the whereabouts of detainees, because we found that before then people were detained incommunicado. So, we are grateful to the working group. The ACJ forced us at the law school to adapt our criminal litigation module. Before then, we were teaching the CPA and the CPA, but with the ACJA, we now had to introduce provisions of the ACJA in the module. So we consider ourselves partners in the
of interest to me, section 352 sub 4 and 5. Section 352 sub 4 provides for trial in absentia. But if a defendant is prosecuted and convicted as envisaged under section 352 sub 4, his sentence cannot be done immediately. And at the end of 90 days, the trial judge is functus officio. I think it to convict and sentence. Whenever the accused turns himself in or is apprehended, the sentence will not be a waste. Thank you.
Thank you, Prof. So before my last statement, I wish to acknowledge my Lord Honorable Justice I.U. Bello, because the first or the pilot rules of court that the Institute drafted in 2018 was the FCT rules of court on application of criminal justice. Yes. Yes. And my Lord gave us all the encouragement, the support, most importantly, the buy-in. Professor Akpe was also on that team. And over time, that has actually been the template we've been using because of the, for other states. Thank you, my Lord. And Right Honorable Professor Ali Ahmad and my distinguished senator from Kwara State. So I also wish to let you know that the Institute also drafted the rules of court, the Kwara State Administration of Criminal Justice Practice Direction in a lorry in May, where the rules was signed by the Chief Judge, Honorable Justice Adebara, and the Rules Drafting Committee. Yeah. So as my final words with regard to the SCJ, we acknowledge the little steps, progress we have made. We understand that the law came into effect in considering the challenges that we've had and the ingrained practices that we've always had. So we believe that going forward, that these little steps will go into major miles. Thank you very much.
Thank you very much. I just want to use the opportunity to thank all those who have worked assiduously in the last 20 or so years to get this law where we are. I think we've made progress. We actually congratulate ourselves. At least the framework is there. Awareness is growing. And like my Lord said, getting magistrates involved in this process, police who are the entry points of both the investigation and adjudication, very important. And I just want to say that we thank the development partners. As a matter, they have pushed and pushed and pushed, and everything being done in the civil society, most of it is being done in ACJ as civil society driven and also supported by development partners. So there was no fatigue of funding. So I want to encourage the development partners to continue to support the awareness, so that next 10 years, like Justice Oyewole said, when we do an assessment, we'll be far, far, far ahead from where we are now. But we must pat ourselves at the back to say that we have done well in this country on criminal justice reforms. Thank you.
Thank you very much. My Lord, I will say that at the coordinate and superior court level, the implementation has done very well. And when I attributed 30% success to implementation, I'm sure it refers to the practice at that level. But unfortunately, just as highlighted by my Lord, Honorable Justice of the JSC, that majority of what goes on happens at the lower courts, especially at the magistracy. Focus should not be there. And of course, with the IPOs, and there are still lay prosecutors in many of the lower courts. We need to pay attention to them to see that properly funded, properly educated, and then awareness too, as highlighted by Prof here, that the public need to know and understand. And of course, our practitioners, many of them who are operating at that level also need to be made aware of some of these practices. A situation where magistrates, as we speak, there is a correlation psychologically between optic and value. Many of the magistrates are so neglected, especially at the subnationals in the states, totally neglected. I give a picture of a magistrate who is going to court on an Okada with his orderly and his books on top of the same Okada. Expect that magistrate to be the supervisor of his DPO. I mean, DPOs still do not even consider magistrates as their value. So we need to fund that level of court effectively. My Lord, when I was Attorney General and I tried my best regarding the pensions of judges, got my governor, we wrote a letter to my Lord the CJN, hoping that the NJC will look into it and take it up and take it from the states. Many of the states, judges are dying, non-payment of pensions and gratuities. And unfortunately, I got a reply with a rebuke that I should instead talk to my governor to ensure he does what he's supposed to do. Our own understanding of the interpretation of the Constitution at that moment was that the NJC could take it up. The NJC pays their salary, and why wouldn't it pay their pensions? And I think it's still something we need to look into. Leaving them in the hands of the subnationals is problematic. Many of them are dying. So that's an aspect I just want to highlight we need to attend to. Thank you.
So one of the things from here has to be a stronger advocacy for the magistracy because of the important role they play. So when we're addressing the press conference after this meeting, we will take that into consideration.